it on Monday. That's 2 weekend days in there. Anyhow, the pattern over the last 8 weeks that I've been tracking this recently is pretty similar. So the number of new listings coming in the market is exceeding the number sold, and the pending, which is our forward looking for the next 45 to 60 days, is right at or slightly below the number of new listings. And the elephant in the room is the number of price reductions. So basically, we're taking that number of price reductions and adding it to the number of new listings to create the number of new opportunities that have come into the market in the last 7 days. And so what you can see is we've got about twice as many new opportunities coming into the market as going pending, and somewhere close to 3 times the number of opportunities coming into the market that are sold. And it's fairly consistent across Collier County and Lee County. So the market clearly has made a move toward more supply, and the supply has created more competition and less shooting for the moon. And as a result, we've seen, I guess the best word is stability into the market. We're nowhere near a buyer's market or a balanced market, but we're headed a little bit more toward a balanced market. So that's a good thing, I think, overall. It's certainly calming down the market in terms of the number of offers that are being received on property. The days on market will invert here starting in August, because the days on market in a year ago in in June was like 57, and it dropped all of a sudden to like 25. So we've been showing, when we compare month over month, we've been showing the days on the market going down, when in fact it's going to invert here and start to go back up. I don't know whether anybody recalls or can take a guess at what the average days on market was in 2019, but it was pretty close to 90. So now we're seeing days on market, in the 20s. We'll see that start to slide back up as supply increases. So I urge you to keep track of these numbers. One of the things that I think is, for those of you that are on the James Shaw call in the morning, a great way to start off your day, listen to nearly 1,000 people from around the country opine on what's going on in their market. But basically, the market is consistently moving toward more balance, and prices are not. I think that we have to be careful not to paint a picture like 2007, where prices dropped quite a bit. Nobody is predicting a crash. Nobody's predicting a huge decline in prices. None of the major economists or anything I can read are. I think Inman put it well. Stop Googling crash, but stop Googling, big market drop, because it just isn't in the cards. What is in the cards is the increased supply has created a more competition, and more competition, as we know, is going to create prices that are more realistic for the market. So let me just show you real quick here. If you're on MLS, your login page should look something like this. And you should be able then to focus on this widget in the center here. Can everybody see that okay? Just give me a thumbs up. Okay. You see here in this Market Watch, you have the ability to drill down into every one of these things. And you also have the ability to customize, go to another page and put in a geo area, a neighborhood, a development name. You can look at single family homes. You can look at just about many of the things that you can look at in a detailed MLS search. So if you wanted to just look at Naples areas, maybe Naples and Marco, that gives you all of Collier. You can do that. And then when you hit save, it'll go back and it will adjust those numbers accordingly. Now you can look at this every morning. You get a feel for what's going on in the market. And you can look at the price. You can see we had 14 price increases and 255 price decreases. We had sold 230 and new listings 205. So the pattern, over the last 7 days in Collier is very consistent, what we've been seeing. You can also drill down into these various and sort them by list price. You can sort them by the amount of change. This is down 4%, down 6%. So you see, these are down, not huge amounts, but there's an 8%, which is pretty significant. But most of them are going to be. So if I sort this, I don't know whether I can sort this by change info, maybe not. Oh. Anyhow, you can sort it by neighborhood. You can add fields to this, like I can add the days on market here. I can add the days on market. And I can always, and I can move that around a little bit, but anyhow, then I can sort it by the days on market and see what's happening. So you see that still a great deal of these properties that are being reduced. We've gone now to 50. And we've gone up to 75 of the 255, less than 30 days on the market with a price decrease. Okay, so anyhow, you can zero this in on a neighborhood if you want to, if you're studying it for a buyer, or if you're looking for a listing presentation, you can certainly add the, you could come in here and add the development name and sort it by the development. So you can do quite a bit to create yourself a nice custom report there and sort this by development name. Okay. Just to give you an idea of the flexibility that this has in MLS, and something that you probably want to be involved in looking at least a few days a week. Also, if you have a listing, I strongly recommend you set up a search and have that search notify you via email of any change in the neighborhood that, the nearest you can define as a homogeneous area, like the subdivision, or an area 1 mile around your listing if you're in Naples Park or something like that. And then have that listing notify you by email when something changes, so you can constantly keep in touch with your seller and show them, what's going on in the neighborhood. I guess, one of the calls that Denny Grimes call on Friday said, you can't over communicate with a seller in this market. You need to let them know that you're on top of what's going on and that you are keeping an eye on everything that's happening and that you're acting, in their best interest. So, all right. So let's shift gears here a little bit and go into some contract discussion. Is there anybody that wants to ask a question about the market or share something that they've experienced recently with a buyer or seller?
Hey, Jeff, it's Mark.
Hey.
I just wanted to make an observation that right now is can be a sweet spot for buyers, that the market activity and showings may have been down in recent weeks for sellers. And as we get into the middle of August and towards the end of August, sellers develop a sense of bravado that if they just hold out till October, that all the buyers from up north will be back down and they'll get top dollar. So what I've noticed in the past is that when one neighbor lowers their price, it starts sort of a domino effect. Well, if the neighbor's home has been dropped 2%, eventually the seller of the other property says, well, in order to stay competitive, I need to adjust my price. I'm not suggesting that's going to be a cascading effect, but watch for that. As you say, when you get the email notifications and you see one price notification, that should send up your antenna that if there's one price adjustment, start watching to see if there are more that follow it.
Now, that's a great observation. And you notice that the price drops were not, other than a few that were 7-8%, most of them are small enough. What that does is obviously that gets you into the Zillows and the, it gets you focused on something new happening. So when you're taking a look at the market, the price drops and everything get first billing. And if you're using showing time, you can set your showing time up. If you change the price for your seller, that'll automatically notify everybody that's shown the house. So that's a nice feature to have and good way to keep communicating with people that might have further interest in your listing. But pretty much it's back to work. We were able to take many sellers were able to take a stab and be successful with it. And I think that a number of things have happened, but one of the things that I think everybody can notice is that seasonality is back for the first time since 2019. In 2020, we were expecting the worst, and what we found was people relocating at a fairly rapid rate to get out of the major metro areas and found they could work from home. So we saw that happening, and then 2021, of course, turned out to be one of the best years we've ever had in real estate, if not the best. So we're following a couple of years where people really didn't leave, and that fed the frenzy of, I can't go back home, and I don't want to, leave and have prices go up even more. So there was a lot of a feeding frenzy that could, that took place, and that didn't take place now. So I'm just.
Hey, Jeff.
Yes, go ahead.
Yeah, the other thing that I find interesting is the interest rates, right? So I'm on a couple different email lists to get updates on, a regular basis regarding interest rates. And even though the Fed increased the rates, 0.75% last week, the interest rates have gone down. So I'm not quite sure. I don't understand all the ins and outs of the economy to understand why this is happening, but even, the chief economist for the NAR, that Lawrence Yun, I don't know how to pronounce his name. He's even speculating that the 30-year fixed mortgage rate may settle down at 5.5% or 6% for the remainder of the year.
Yeah, there's a couple of pretty good mortgage people that write newsletters every week, and I kind of follow them. But basically, I guess these things are baked in. Everybody kind of knew that the Fed was going to raise the rates, and everybody knew. So some of these things are baked into the rates before they actually happen. And the slightly downward fluctuation has to do with the fact that the Fed rate or the prime rate doesn't directly affect mortgage rates. Mortgage rates are based more on long-term securities and bonds. So there's different influences on these various things, and it's hard to pinpoint them. But one thing I think from talking to some of the people that I've dealt with for years here in this market, mortgage people, is that, look, for quite a while, the Fed was buying was selling treasuries and taking the money and putting it into buying mortgage-backed securities, which kept the rates artificially low because the Fed was the major investor and not investors who are looking to get a rate of return. So now the Fed has stopped doing that, and the investors are back in having much more control on the going rates. And these people seem to think that somewhere, 5.5 to 6.5, or not quite 7, but let's say 6 is going to be an area where the investors will probably remain because they need to make a return, and the Fed is not artificially flooding into the market large amounts of cash to buy these mortgage-backed securities. So I think, they're expecting some fluctuation up and down in the 5s, but maybe, in the near term, it'll level off around 6. So that's double more, or a little more than double what we faced a year ago, which directly affects, I'm sure, affordability. That's also having, I'm sure, a little bit of a downward effect on prices because people can't afford as much. And I know I look at some of the contracts now, and I see offers going in below the list price. Not that they'll settle out there, but I think people are more comfortable making offers that are not, way over the list price. So there's a lot of different things going on in this market, all of which favor the hardworking group that we are, because we keep up with the market, we have the knowledge. And remember, most consumers, they read the newspaper, they watch the news at night, but they're not knowledgeable in what's happening in their neighborhood or what's happening in their market. And that's where, by adding value and by adding this information, that's where we can help as professionals. So it's as they say in the James Shaw call, the shift in the market favoring the professional. It's favoring the person with information. It's favoring the person that can make suggestions to their buyers and sellers that are more effective in today's market. And one of the things, they're on, I don't know how many of you are on Denny Grimes' call on Friday afternoon from 1 to 2, but he gets about 100 people around the country on there, and they do a great deal of script and role playing, or dialogue, and now called dialogues. But the effect of it, one they had last week was, if you're a listing agent, maybe you could make an offer to a buyer. You see things coming in, you see people asking you questions, you see people saying, well, what about the air conditioner? I see it's pretty old, that sort of thing. Well, what's stopping you as a listing agent from putting an offer together for an interested buyer and say, hey, what would you think about these terms and conditions? And maybe get the dialogue going with a buyer who's not exactly sure, where they want to land. So a lot of creativity in a market that is really going to reward the knowledge-based agent, the professional agent. And that's why I'm working hard to get you as much information as I can, not only pinpoints and comparisons to last year, but trends over time, so you can start to see what's happening in the market. Anybody else want to chime in? Okay. I've got some questions here that we put together for our Ask the Attorney panel, which are contract related questions, and they're not really in any sequence, but I wanted to throw them out there and maybe talk a little bit about them today. Let's see. Can everybody see that okay? Yep. All right.
Yes.
So again, these are not in any order. I put these together when we started doing our Ask the Attorneys panel, but I find that there's points in here that can, make good items for discussion. Okay. And, we can skip around. If there's one that you particularly like, just say, hey, let's talk about 10, or let's talk about 5. But if you start with radon and mold, the contracts in our market are very different. If you look at radon and mold in the NABOR contract, they are specifically addressed and defined as defective items if certain conditions occur. Radon over 4.0 and mold, non-allergenic pathogenic molds, allergenic and pathogenic molds are a defect, but non-allergenic molds, particularly Aspergillus and Penicillium, are considered non-allergenic molds. They're everywhere in Florida, and you know, if people are like, I don't want any mold, then maybe you could head to Phoenix or or it's hot and everything's burning. But you know, it's a fact of life here, and probably the most nebulous part of inspection items and dialogue is mold, because there really isn't any when things come back from the lab. When things come back from the lab, then one lab might call it an elevated sample, one might call it not elevated. So you can sometimes get two different mold tests from the same place and get entirely different results. So you have to be careful with mold as a realtor. You know, you want to know if your customer is, you know, has terrible allergies, or their children have allergies, and they might be more susceptible to different kinds of mold, and they might want more protection in their contract, not just the standard that we've set. When we look at FAR doesn't redress radon at all, and it has now a mold rider, which is basically a fairly oh, sure. So, you know, there's a mold rider that's been added to the FAR contract, which is strictly a dollar amount. If the remediation cost goes over a certain dollar amount, the buyer has the right to cancel, which is certainly better than nothing, but it surely is difficult on the seller who may be willing to do some remediation. Maybe it just needs a good cleaning. Maybe there's a leak in the water line to the refrigerator that they didn't know about. But you know, the at least in a FAR contract, you have some protection for your customer there if there is mold found. And then the next question is, when do you do a mold test? I know when I was an agent, I did a lot of mold tests, and they didn't necessarily pick up mold. If there's mold behind a wall and there's no mold in airborne mold, a mold test may not pick up mold. And they go to do some renovations, they pull the drywall down behind the cabinets and it's loaded with mold. So it's a difficult subject, but one that you definitely want to talk with your buyers. One of the things that I've always kind of recommended after dealing with a number of inspectors is most inspectors now have mold testing and mold remediation in their repertoire. And if your customer is concerned about it, one of the things you can do is, if your inspector has mold testing capabilities and mold remediation capabilities, you can ask them during the course of the normal inspection to see if they find any conditions right for a mold test. A wet wall, you open up the sink, the kitchen sink, and under there, the boards are all warped and there's signs of water stains and things like that, where there might be an indication for mold. Obviously, if you've all done enough showing that you walk into a house and it's like, something doesn't smell right here. It smells damp, smells kind of nasty a little bit. There's cases where you definitely want to have the mold evaluation done. So does anybody have any comments or questions on radon and mold? It's an audience participation class. You know, there's several of you on there. So if you have any questions or you've experienced a problem.
Jeff, do you have a notice to buyers sort of form to say that we advise, for example, to get a radon test or a mold test, and that they acknowledge that they've been advise that?
We do not. Probably not a bad idea. I could probably speak with my attorney friends and get something drawn up. This is an interesting issue because buyers don't often order radon tests. They don't often order mold tests unless the inspector finds something that they believe. You know, it's not a bad idea. The radon subject is one with a great deal of concern because radon up north with basements and subterranean structures you don't have here can be a much bigger issue. So very good.
Yeah, I just foresee that some buyers, after they close, discover that there's signs of prior leaks and perhaps mold that was remediated and it wasn't disclosed. And the buyer sort of says, well, I'm not going to spend the money on a mold test. And then they come back and say, well, you never told me to get a mold test. And they've forgotten the conversation where you recommended it.
Yeah, no, I agree. I mean, it's certainly, there's some recourse to the inspector if there was an obvious situation there that the inspector didn't point out in their general inspection and didn't mention anything. So there's some culpability on the part of the inspector, but obviously they take a look at Keller Williams with 180,000 agents and who are you going to sue? So I surely understand that, and I think that's a good point, Mark. So has anybody else had an experience, good or bad, with mold or radon that they want to talk about? Radon is another one that's fairly complicated.
I had a question about mold. So I had an experience where a buyer buying for the first time here in Florida, they came across, the typical mold that you find around if they haven't kept clean around the air conditioner in the garage, right? Mm-hmm. And all of a sudden it was, oh my God, this house is full of mold. And so I explained everything to them about how they need to go in, if they need to go in and they need to drill. I mean, if they really think this is through the house, they need to bring a qualified mold inspector in. Anyway, they didn't really listen. They kind of got their own contractor, and it was pretty embarrassing for me in front of the other agent. And she had mentioned that you can't, if they were going to remediate the mold, they couldn't use the same contractor.
That's correct. You cannot use this. There are licenses now for mold inspectors and for mold remediators, and you cannot use the same person for both sides of the discovery and remediation process. That's a statewide regulation.
Is that true also for radon?
I've certainly not heard that. The radon mitigation process is a little bit more straightforward. I'm guessing that that's up to really the buyer and the seller. If the radon is 8, then the buyer can say, I want you to give me a credit and I will hire a radon mitigation person, or I want you to remediate it before we close. So the radon mitigation process, I guess it's a little more straightforward in that it involves somehow bringing a fresh air source in from outside and driving the fresh air into the plenum of the air conditioner where it mixes with the inside air. And that's what, when you first look at that, you go, I wonder why that's going to help my radon count. But that's the established technique for mitigating radon. It's gotten a lot more complicated in the last few years because now you usually have to get some kind of permission from the association, and then you have to get a permit, and then you have to actually do the physical work, and that can take 30 to 45 days, depending upon how extensive the HOA approval is or the condo association approval is. And oftentimes that extends beyond closing. So then the question becomes, you know, the buyer gets an estimate, the seller gets an estimate, they try to work out a credit or delay the closing. But I'm not familiar with any type of regulation that says that the radon tester can't be the radon remediator, because their processes are fairly straightforward. The radon test is pretty established, and so is the mold remediation or the radon remediation. Okay,
Thank
so if everybody's okay, we'll move on to question 2. Hopefully some of these are going to be stimulating and educational. There are some significant differences in the inspection processes in NABOR and FAR contracts. So let's take the NABOR contract first. The NABOR contract provides for either an as-is due diligence or an inspection period, and there's an established time frame that goes that the buyer gets a approved timetable, default to 15 days for inspections. Then they have 5 days after the end of the inspection period to make a formal request to the seller to repair defective items. And they have to be defective as defined by the contract. And I have, you know, a little matrix here that I can share with you that I put in the library for today. So basically, if everybody can see this, this is basically a slide that I put together talking about defective and cosmetic items, but it's very well defined as to what the inspection process is. And if you would like this as your, like a cheat sheet, it basically, these are the line numbers in the contract that deal with inspection items and deal with what's defective and what's cosmetic. And it's well defined. And where I draw the line with my disdain for as-is contracts is none of this applies to any as-is contract. So the buyer can literally ask the seller for anything, whether it's defective or not. And there's a catch-22 in an as-is contract that once I've asked the seller to address a defective item, even though there's no definition of what is defective in an as-is contract, but now I know about it and my agent knows about it. And then if I decide not to take action on it, do I have to disclose it to the next buyer? And the answer is by code of ethics, yes. So anyhow, this is just a brief. If you'd like this, just shoot me an email, jonesnaples@kw, and I'll be glad to send it to you. A lot of people like to have it as a handy reference when they're sitting there with their customers talking about what the contract can and can't do for defective items. But if I go back to the questions here, FAR bar, well, one last thing. So the process is I inspect for X days. I have 5 days after the end of the inspection period to make a request, buyer's request and seller's response. And I have then the 10 days up to 10 days for the seller to respond. And then I have, okay, Victor. And then I have, I have 5 days. If you put your name in the chat, I can also write your name on the list there. So then I have 5 days after I receive the seller's response to decide to cancel if the seller says, I'm not fixing a defective item, or if you have to be careful with your seller to fill out the seller's response, if I've offered a combination of actions and credits that don't, in the buyer's mind, address the defective items. So there's a little window of 5 days after I receive my response from the seller. So it's a fixed process. FAR bar works entirely differently than NABOR. FAR bar has 3 buckets in the inspection in the standard contract. It has general repair items. It has wood destroying organisms, WDO, and it has permits. Whereas the NABOR contract addresses all defective items in the same way, the FAR bar breaks it up into 3 buckets, and you as the agent need to work with your customer because there's a number that you put into each of these 3 buckets. It's either a dollar sign or percentage of the selling price. And these 3 buckets stand alone. So if there's general repair items in there for 1.5% of the selling price, and it's a $500,000 contract, that's $7,500. And if the repairs are 10,000, the seller is only obligated to repair up to what's in the general repair bucket. And they can't take money out of the wood destroying organisms bucket or the permit bucket to compensate. So it's a defined amount. If that amount exceeds that, the seller can say, I'll repair up to what I agreed to, 7,500 in this case. And so you tell me, Mr. or Mrs. Buyer, what you want me to repair. I'll repair up to 7,500. Or the seller can say, hey, I'll repair it all. It's reasonable. But definitely each bucket stands alone, and FAR bar defines cosmetic and defective items a little bit differently than NABOR. You need to make sure you understand those differences. It's mainly small things. Torn screens are a defect in FAR bar. They're not a defect in NABOR. So there's a few items that are slightly different that you can look in the contract and tell, but for the most part, FAR bar is 3 buckets and NABOR is all in 1 bucket. In FAR bar, you must make your request to the seller during the inspection period. There's no 5 days and then 10 days to respond and then 5 days. You have to make your request of the seller before the expiration of the inspection period. Very important, because there's no 5 days after the end to make your request. And if you don't make the request during the inspection period, then the buyer is deemed to have accepted the property and condition is in. So you want to make sure that you have that inspection date handy and that you get your request over to the seller prior to the end of the inspection period. The seller that can then respond, but there's no back and forth involved. There's basically a slight clause in the FAR bar contract that says if neither party communicates with each other about defective conditions, there is the facility for, in other words, if the buyer makes a request and the seller does not respond, there is an ability for the buyer to cancel. Any questions? Obviously, that's a mouthful, but any questions on inspections, any problems you've had recently, anything you'd like to discuss in the way of inspection items? Again, this is the audience participation part where you too can chime in. No?
You covered it so completely, Jeff.
Oh, great. Well, I've done it once or twice.
Yeah, she beat me to it. I couldn't get that in before she got me there. I was gonna say the same thing.
All right, well, thank you. I take that as an extreme compliment. So this is another one that I see a lot of in contract classes. When is the effective date? It's 0. Remember that. I would say a lot of the calls I get and a lot of the disputes that I hear people get into is because they count from day 1, and especially on deposit dates, inspection dates. Those periods of time flow from day 0, which is the last date on the contract when it is either party has signed or initialed. So again, a best practice is to make sure that your customer initials and dates everything or signs and dates everything because I've seen a lot of counter offers where there's a bunch of initials all over the place and no dates. So that reverts back to the last time there was a date, could be the signature date. So you could lose several days on your inspection period or your deposit due dates because there was not a date next to your customer's initials, which would have modified and become the last date when either party makes a change. Again, remember that all offers and counter offers are accepted and delivered, meaning that just because the buyer signs a counter or the seller signs an offer, if they don't communicate it back to the other side, email is the general method because it's a time stamped method of doing it. But that date is got to be within the confines of the offer and counter offer period. And remember, it's accepted and delivered. How to calculate the contract due dates and when do they carry over to the next business day? Okay, here's another one. I would say that there's a pretty significant misconception on the part of many agents as to how dates are counted. And it says right in the contract, both contracts work the same. It's calendar days unless the deadline ends on a weekend or federal holiday or the observance of a federal holiday, like Juneteenth. The Juneteenth holiday was Sunday, but it was observed on Monday. So that Monday became a federal holiday and the next business day was Tuesday. So anything Friday, Saturday, or excuse me, anything Saturday, Sunday, or Monday would automatically carry over to the next business day. And it's at midnight. It's not at 5 o'clock, it's at midnight. So all dates, all time periods end at midnight. So I can say that many of the discussions and disputes that I've been involved in have to do with the way these things are counted. Oh, you don't have to worry about it. We don't count Sundays. Oh yeah, we do. The only time we don't count them is when it's the due date or the end date of a period. So can we mix FAR and NABOR forms in a contract? Never. I'll tell you why. The terminology is different. The defined terms are different. The line number references are different. And if you were to mix one of the things that we see a lot of is they use the condominium rider from the FAR contract with the NABOR contract. And the reason is they can't find a NABOR condominium disclosure or condominium addendum, and that's because there isn't one. The statute calls for the buyer to get 7 documents from the seller, and when they've received all 7 of those documents, then the 3-day period begins. Date of delivery to the agent of those documents does not count. Date of delivery to the buyers is day 0, and there's 3 business days after delivery to the buyers. So a trick of the trade is deliver your condominium docs to your buyer on Friday as day 0. They have until the following Wednesday to end their review period. So they picked up an extra couple days by the fact that the weekends don't count in that process. So if you have people that are particularly interested in diving into the details of the condo docs, try to give them an extra day or 2 because they can be laborious. The other piece of trivia that I will give you is that now into the NABOR library is the latest version of the Florida Condominium Governance Guide, which was modified for 2021 and 2022. It says it right at the bottom. If for some reason you were to supply the old one as one of those documents, you could be in a situation where the buyer could say, I never got all the docs. The one you sent me was out of date. So make sure I know in the NABOR contract library, I'm pretty sure in our contract libraries, we have the most current version. But if that condominium governance form doesn't say modified 2021, 2022, and you don't have the latest version, and you could be considered not supplying all the documents. I know that's kind of picky, but it is what it is. So again, mixing documents, forms, everybody loves the post-closing occupancy language in the NABOR contract. And no, you cannot just attach that to a FAR bar contract.
Hey, Jeff,
Yes?
a question about those condo docs, because I did run into the situation where I actually received the condo docs. I think it was on a Saturday morning. But I don't know if I was traveling. I wasn't available until, I don't know when it was, when I saw the email on either late Saturday or early Sunday.
Okay.
So am I under any obligation to, once I receive those, is there a timing that I am either under obligation to or that's considered ethical that I send those on to my buyer, or could I have waited until that next Friday and sent them on to my buyer?
Well, technically, there's nothing in the contract that says when you have to supply those. It's really technically it's the listing agent's responsibility to supply them to you. But I know when I was a listing agent, I uploaded every one of those documents, including the governance form, into the attachments and said, here they are, and here's the form. So, you know, whenever you delivered those to your seller, that was day zero, or your buyer, that was day zero. And they had, but I don't think there's anything in the contract that says if you got to deliver them day after, you can deliver them when you deliver them. I think it's 10 days to do it. That would be a little bit of a problem. So, I mean, I don't see it if it's extra day problem. So I don't really know that I have a great answer to your question, but I don't know of anything that says, hey, within, you know, 1 day of receiving all the docs, the buyer's agent must present them to the sellers. It's a flow. And I will tell you that unless you have a listing agent that's very diligent, chances are you got to go chasing those documents for your buyer. And, you know, you can ask, but there's nothing that says that in the contract that says that the seller's listing agent must provide them. It's just a courtesy, a professional courtesy. So you may have to go digging for those yourself. You can get the most of them, if you call it the title company, they can connect you with them. I can show you how to get them out of the clerk of courts site, you know, Collier Clerk or the Lee County leaflet. So, you know, I don't think it's a big deal as long as it's not used deceitfully, right? I mean, I think that's the best way I can answer your question.
Jeff, you and I have had the conversation, but I'm making it part of best practices in my business as a listing agent to have the buyer sign the receipt of condo docs before the seller accepts the offer, assuming that they got them all, but not leaving it open-ended and then have the buyer come back 2 weeks later and say, well, I'm exercising my right because I never signed the receipt of condo docs to terminate the contract.
Now, I saw more of that in multiple offer situations this year because basically the seller was saying, look, if your offer will not be considered, or your offer will not be considered the best offer unless your buyer submits their signature on the receipt of condo docs. So one way to make your buyer's offer stronger is to give them those docs and have them review them before you submit your offer, and submit your offer with the signed submit your offer with your signed contract, and then there's no 3-day rescission period. The buyer's already had that review period, and there is a checkbox in the condo rider for the FAR bar that the buyer has received all the docs and does not expect, you know, a 3-day right of review. So that's another, if you're using FAR bar and your buyers are okay with it, they can make their offer a little stronger. But I would say out of all the angst that I hear, you know, in general about the contract is that NABOR does not have a condominium rider. They require the 7 documents and they never can get the receipt of delivery or the proof of you know, the receipt back timely. So that thing's always hanging out there that the buyers can say, oh, you know, here's my dates. I'm within my 3 days. I'm out of here. And I think, well, you know, what I've read in the latest Florida Realtors publication is that the number of canceled contracts has gone up significantly in the last 5 to 6 weeks. So I don't know whether that's one of the reasons that people are using that as an escape hatch. I don't really know. I know that there's obviously a lot more listings out there. There's a lot more opportunities out there. So that gives people that right as is contracts, the result, you know, the easy, oh, I just saw another one I like better. Let me bail out of this one and go into another one. So there's a little bit of that behavior going on because the supply has increased pretty significantly and pretty quickly. Anybody else on that one? Okay. Is a seller's disclosure required in Florida? No. The answer is no. And what part of no don't you understand? You know, there's no requirement for a seller to fill one out in Florida and no requirement to provide it. And many times I've heard agents say, well, you know, my broker says we can't accept this contract unless there's a seller's disclosure. Obviously, a seller's disclosure can be viewed as protection for a seller and or a broker because of the disclosure in there that protects any finding or any information that the buyer learns in their due diligence period that was not disclosed by the seller. So that being said, there is no seller's disclosure required in Florida, but the seller is required to disclose any defects that could materially affect the value of the property and are not readily observable. That's Johnson v. Davis. Does a seller have to disclose a defect they don't know about? No, but believe it or not, there was a major court ruling that said, you know, I didn't know about the defect, therefore I didn't disclose it, therefore you can't hold me accountable for it. But the buyer was trying to hold a seller accountable for something the seller apparently proved beyond a reasonable doubt that they didn't know anything about it. So there you go. There's another one where I see, well, you have to send me the seller's disclosure. No. And does the buyer have to sign a seller's disclosure? No. So if your buyers, you're looking through the seller's disclosure, you know, other things in there that are a problem, that could be a problem, but there's not enough information in the seller's disclosure, then one thought you have is to suggest to your buyers, I don't know that I'd sign that because we don't have any proof or any more detail on what they've written in the seller's disclosure. And, you know, like, for example, do you have radon? No, but I had it and I remediated it and there's a remediation system in place. Is that a failure to disclose? Is it if your neighbor's water heater bursts above you and floods your unit out and it's all taken care of, it's all paid for by the neighbor's insurance company and it's perfectly remediated and there's no discussion, do you have to disclose that? Again, if you're on the fence about it, we can certainly put you in touch with an attorney to make sure you're on solid ground. But a seller's disclosure is not required, but a seller must still disclose anything that could materially affect the value of the house that is not readily observable. Okay. Comments on that?
Jeff, could you talk about the practical side of what it costs to have an attorney litigate something?
Yeah. If, basically disputes in Florida contracts, if they're not defined, the method of dispute is not defined, basically have to be done with a litigating attorney. There has to be a lawsuit filed. And we asked the attorney on this panel that we had a month ago, they said, well, what amount of dispute of a deposit or a repair or whatever, what amount would a buyer have to have in order to really be willing to invest the money to sue a seller? And the attorney said $100,000. So if you've got a $10,000 deposit dispute, or you've got a dispute over the fact that the air conditioner was, supposed to be have been replaced in 2019 and your inspection finds it to be, 2012, there's just a limit to what leverage you have. Now, FAR has a dispute resolution system that includes mandatory mediation and arbitration. NABOR is silent on that, but I would say 90% of all these things are going. The disputing party has to offer mediation. The defendant can say, no, I'm not going to mediate, but they'll try to use lower level techniques to try to come up to some meeting of the mind. How do declared defects in the seller's disclosure affect the seller's obligation to make repairs? Okay, so if my ice maker has never been used, I hate ice makers. I think that they're bacteria trap, and I don't hook up my ice maker, and the inspector comes along and says, I couldn't test the ice maker because it didn't work. And in the seller's disclosure, the seller said the ice maker has never been used, it's never been hooked up, and I'd never used it. So the sellers basically disclose the fact that they don't know anything about that ice maker, that they've never used it. So if the inspector comes along and says, well, I think the ice maker is defective because it's not hooked up, does the seller have the obligation to hook up and repair, if necessary, the ice maker? I would tend to say no. If you say my garbage disposal doesn't work, I never use it, and the buyer signs that, does the seller have to repair the garbage disposal? Probably not. There's language in the NABOR contract, right in the seller's disclosure, that says if I disclose something and say that it's defective, but I don't intend to address it, and you, Mr. or Mrs. Buyer, sign it, then I'm off the hook. So you have to be a little careful about that on both sides. But a seller that says, I've disconnected the garbage disposal, I hate them, I'm never going to use it, I don't know whether it works or not, and puts that in the seller's disclosure, chances are, if the inspector comes along and says garbage disposal doesn't work, it's not connected, that chances are the seller does not have to address that because they put it in the seller's disclosure, which is why I think you got to go over that disclosure with your buyer, and before your buyer signs it, make sure there are no items in there that would cause them concern. And if there are, make sure you negotiate those as part of your contract. The seller's disclosure is a document that can protect the seller. I've also seen cases where it can damage the seller if the seller isn't consistent. I had one that the seller was a widow. She didn't do much on the condo. Her husband passed away. She filled out the seller's disclosure. She don't know on some things, and did she ever rent it? Don't know. I mean, she filled the seller's disclosure out in such a way that it could have been a liability to her because she didn't really know much about it and really wasn't in a position to be able to fill out the seller disclosure intentionally, so we didn't provide it. So you have to be a little careful that what the seller puts in there makes sense, and that the seller's not disclosing things or putting things in there, or, do I have radon? Don't know. That's, like, well, if you don't know whether you have radon or not, that means it's never been tested. That there's answers that can mislead a buyer, and you need to be careful that your buyer doesn't sign that and put themselves in a position where they don't have any leverage to get it repaired. How are we doing on time here? Good. What is the seller's obligation to maintain the property once under contract? Okay, now, if you take a contract class from me, you'll know that I think this is one of the most important parts of the contract. Because whether it's as is or regular, from the day there's a meeting of the minds and an effective date in a contract, the seller has to keep everything in that same condition. So one of the reasons that I'm very much vehemently against waiving inspections is that there's no baseline there for you to establish the seller's maintenance obligation. If you saw it today and you wrote a contract Friday and you didn't inspect, and today when you saw it, everything was cool and calm and looked good, and then when you went for your walkthrough inspection, it was kind of hot, sticky in the place, how would you be able to prove that the air conditioner was working when you went to contract and was not working when you did your walkthrough? So I think that's one of the biggest reasons why I say don't waive inspections, is you need a baseline, because the seller is obligated to maintain the property and in that condition that you saw it. And the only way for you to establish, the property baseline is to do that inspection, and then be able to compare on your walkthrough to what the inspector found when they did the inspection. But the seller's maintenance obligation is particularly important. And if you have the seller, and the seller says, well, I'm gonna cut back on the landscaping, I'm gonna water once a week instead of 3 times a week, things like that. And they affect the property's not in that condition. When I go for my walkthrough, I have the ability to ask the seller to escrow up to 200% of the cost of repairing the item that didn't get repaired, or repairing an item that was working at contract date. And that 200% does not release the seller from having to make the repair. So if we escrow $2,000 to repair an item that wasn't properly repaired, or that was working when it went to contract, let's say it's a pool pump, and let's say it costs more than what we escrow for the repair, the seller still has to pay the full amount. Okay, so the seller's maintenance obligation is really the heart of the contract. The seller says, I've got to turn this over to you in the condition was in when we agreed on a price and terms. Any comments or questions on that?
Nope. And I have a comment, because I had a buyer that wanted to waive the inspections and said, we're just going to purchase a home warranty. So that gives us a sense of security, right?
Okay.
And so they waived it. And then when we went in for the final walkthrough, the air conditioner didn't seem to be working the way that it was. And I explained to them, they didn't have a baseline. And so there was really nothing that could be done, because even though you felt the coolness, there was nothing that, there was no proof of that. So, I think sometimes if you, in working with buyers, instead of totally waiving the inspection, and it was during the flurry of activity, right? So they're trying to figure out how to be the best offer in a competitive marketplace when there's multiple offers coming in. And, still you want to protect them. So I had another buyer then that then said, okay, well, why don't we just say that we won't ask for any repairs if they total over a certain dollar amount,
Yeah,
which
you-
I thought was more reasonable than just waiving the inspections totally.
You can certainly say, I'm not gonna ask you to repair or for a credit for anything, but the baseline is what would have saved them. The other problem I see is the warranty may not cover it because the item was not working when the buyers took possession of the property.
Right.
Warranty
And I,
company
yeah,
could say, no, we don't really cover that because it wasn't working when you took it over. Now, they may not find that. In other words, you could call them the day after you close and they could come out and say, well, it's not working, and you honor the warranty. But they could also say, you know, I don't think this air conditioner has been working for some time because look at this and look at that, and therefore we're not going to cover it. So I think you have to be a little careful with the warranty being the reason to not inspect. What did they end up doing? Did the seller end up doing anything about it, or they just ended up having to eat it?
well, as it turned out, I actually sent somebody else over there, and there really wasn't anything wrong with the air conditioner. They were kind of playing around, putting the temperature up and down. I mean, I've never seen a buyer go in and it was like a 3-hour walkthrough because she checked everything. She did what inspectors do. She turned on the washer, she turned on the dryer. She basically did the job of an inspector. And so I think the conclusion was the ups and downs of the air conditioner that she was playing with somehow triggered it to do something it wasn't supposed to do. I don't know. Anyway, when they finally got in there after a few days, they said the air conditioner's working. Don't worry about it.
Wow.
Yeah, it was nerve-wracking.
They were playing a little Russian roulette there with their.
Yeah, but they wanted their bid to be the best because they wanted that unit, and they weren't going to, follow anyone's advice except for their own. And, she's a real estate agent up north in New Jersey. So,
Didn't have any problem signing our waiver then.
no,
Okay. Well, I mean, you hate to,
but you still feel bad,
but it's interesting that she's an agent and she would let her customers do that up north. Wow. Okay, so what is the term time of the essence and what does it mean for parties to the contract? Okay, so time of the essence essentially means that it's a firm, fixed, defined time and date. The closing date in the NABOR contract is time of the essence. If the buyer does not close or the seller does not close on the closing date and there's no agreement to extend it, then there is a default that occurs because time was of the essence. Many of the other dates in the NABOR contract have some flexibility in them, in that if you were to miss a deposit date and you were to call and say, I didn't get the wire out today, it'll be there tomorrow, there is not an implied default there because time was not of the essence for that date. However, where you have to be careful is, let's say you submit your inspection request to the seller and the seller says, okay, I'm not going to repair these items, sends it back to you, and you have 5 days to decide to close, to cancel and get your money back. And on day 8, you say, I've just decided I'm going to cancel. I think you'd have a great deal of trouble getting your money back. Was time of the essence there? No. But were you out of the bounds of the contract? There are attorneys who argue that because you greatly exceeded that date, that you've lost your rights in the contract. So time of the essence in the FAR bar contract is every date is time of the essence. So no matter what happens, you miss a deposit date, you miss an inspection date, you miss any period of time defined in the contract, and the party that missed it is in default. and the entire amount of the deposits in the FAR bar contract are eligible to the seller as a remedy. In the NABOR contract, remember, only deposits made to date are the remedy for the seller if the buyer defaults. Okay. So we got a couple more time of the essence things that we pretty much covered in the number 10 there, where we said that time of the essence is only the closing date in the NABOR contract, and it is all dates in the FAR bar contract. You can make a date in the NABOR contract time of the essence by giving the buyer or the seller time to cure. So let's say the buyer misses their deposit date, a couple of days go by. You can send a communication over to the buyer that says, if you do not have your deposit in within the next 48 hours, we're going to consider you in default. So you've basically taken a date based on performance, and you've notified the other side of a time to cure. And if they don't cure within that time period, then there's a default that occurs, even though the particular date itself was not time of the essence. But you've made it time of the essence by notifying the other side of the situation and the intent to cure. Let's see. What is a fixture and what is personal property in the sales contract? And how do you determine what does and does not convey to the buyer? Beautiful. I'd really rather have a lawyer answer this question, but there's a definition of a there's a definition of a fixture, legal definition of a fixture, and legal definition of what is real property and personal property. And that's what we do in the first two paragraphs of the NABOR contract, is define the personal property and the real property that will convey if it's there, unless it's excluded. FAR bar has a much shorter list of items that they will consider to automatically convey unless excluded. So you have to be very careful in a FAR bar contract that you make sure you include things like washer dryers, things that are not in their defined list. Where do we run into trouble? Ring doorbells. We run into trouble with ring doorbells and certain speaker systems that are throughout the house, but they aren't, and they're actually sitting on a mount. In the case of the ring doorbell, maybe it's drilled into the front wall. That really is a fixture. So that's where you can get into trouble by not specifying exactly what's going to convey at closing, and assuming that because it's attached to the wall that that's going to convey. Always do an inventory, and if there's any doubt, make sure you define it in the contract. Contract that fell apart, or didn't fall apart, but it went into great dispute. Recently, there was the owner the seller had added a bunch of shelves on wheels into the laundry room for storage and countertop space, and they were on wheels. They weren't attached to the wall, and she took them when she left, and the buyer asserted that they were fixtures because they were shelves, but because they were on wheels and they weren't attached to the wall and they weren't mentioned anywhere, the buyer really was not properly protected. But I don't know that, I guess you would have had to notice that they were on wheels and that they weren't attached to the wall. But a TV can be a problem if it's a 85-inch plasma sitting above the fireplace and it's attached to a bracket which is attached to the wall. Then it is not a fixture. The bracket is a fixture, yes, I agree, but the TV is not. So if your buyer is expecting that TV and you don't want to make a run to Best Buy you probably want to make sure you define that in the contract, that the TV over the fireplace is part of what's going to convey. Or a separate inventory that everybody signs off on, can be a photo inventory, can be a written inventory. But the foolproof way to make sure that there's no drama at the walkthrough inspection is to have some kind of a written or photographic inventory that everybody's agreed to. And remember, if there's financing involved, the lender does not want to see a list of furniture or other items included in the contract, because they will take umbrage to saying we only want to finance the real property. We don't want to finance a bunch of furniture and things. So there you go. We have time for one more, I believe. How do as-is contracts differ from standard purchase and sale agreements? Well, we do a whole class on as-is contracts and what the differences are and what's different in inspections. Again, if you take enough of my contract classes, you will know that I'm really I have extreme dislike for as-is contracts. I think people become enamored with the ability to walk away instead of the ability to work it out, because if you really wanted the place, wouldn't you do a contract and try to work out your differences? Or do you want to take the property off the market for 8, 10, 15 days and then just say, no, I changed my mind? If I'm a seller, I'm not happy with that. And also, if I'm a seller and we go to contract for less than my asking price, and then all of a sudden you come back and ask for a credit or a bunch of repairs, I'm not going to be happy with that either. So there's a lot of reasons why as-is contracts came into vogue when banks were selling properties. They knew nothing about the property. They had no intention of making any repairs. You were deemed to bid on that contract and take it as is. So that's where those contracts were effective. Personally, the whole repair process is very difficult in an as-is contract, because there's no standards for what's defective and what's cosmetic. There's no standards that you have to use professional people unless you write an amendment to your as-is contract and maybe have an attorney help you draw it up. But it basically should say, hey, we want these defective items repaired by a licensed professional, and we want receipts to prove that you did the repair. Okay, well, you're not capable of sitting down and writing an amendment like that. You need an attorney to help you with it. So I think that as-is contracts they're kind of gradually disappearing, although there are entire brokerage houses that insist on that's the only contract that you can write. So they're still going to be around, but I think people have started to realize that there are pros and cons to these as-is contracts, and why not write a regular contract and put the terms and the conditions in there that favor, the deal staying together. So with that, Broker Jeff will get off his soapbox and about as-is contracts and argue that there are cases where people want to use them, and it's really up to your customer whether you want to use that technique, and up to your seller whether you want to accept that technique. But I think that the sellers need to understand the pros and cons of accepting an as-is offer and what can happen, even though the contract itself says, I'm going to take it as is, and it's a right I've bargained for, and the seller's saying this is great, but maybe it's not. And again, the seller's risk is taking the property off the market for the period of time of the due diligence. And the buyer's risk is that they, ask the seller to repair things and ask the seller for adjustments, and the seller says no. So there you go. But like I say, I still, especially in Lee County, probably better than 90% of all the contracts are as is. So it's still a widely used technique, and it seems to become very attractive, the ability to walk away. Okay, well, I think, there's probably some good stuff in these questions. They are kind of allow you to travel all through the contract and talk about various important points. And Mark, you raised your hand. What you got?
Do you want to comment on two classes that are coming up at NABOR? One is the CIPS designation and the other is the RSPS.
Okay. Yeah, I mean, the RSPS isn't one day. Is it 1 or 2 days? I think it's 2 days, resort second home. That designation is, I think one of the major points of it is referrals. People will refer a resort community and people will refer resort, the RSPS designation. They'll use that as a criteria for your for a referral, so you can help yourself with referrals. And the CIPS, I think now they're it used to be quite a bit more expensive and take quite a bit more time to get your complete certification, but now I think they do it over a couple of week period, Mark, and I don't think it's it used to be, you know, quite a bit more expensive to get the designation. So what is do you recall what the cost is?
Hold on just a moment.
Let's see.
It looks like it's $200, but there might be a discount of to $150.
Yeah, when I first looked at taking that CIPS, it was close to $1,000.
Yeah, I agree.
Do the electives and all that. And so again, for referrals, the CIPS is probably, if you ask me, other than possibly GRI, you ask me what the #1 designation would be to get referrals, especially international customers, it's CIPS. And it's a great, I've taken most of the classes. I think I have to take a couple more to get my designation, but it's good stuff. And the people that teach it are pretty knowledgeable. They've done a lot of international transactions, and they can help you a lot with what you can learn in that class. So thanks for sharing.
And just
Jeff,
like the GRI, we don't pronounce it agree. We don't pronounce the CIPS as a SIPS.
And we don't pronounce NAR as NAR. All kinds of things that we don't do. So there you go.
is that one of those that then there's an ongoing cost for?
RSPS, no. CIPS, some of the designations, ABR, and some of them do have an ongoing annual membership. I'm not sure about the CIPS.
Yeah, I believe there is an annual dues.
In many of those, there is an annual, it's, you know, $100 or $200 to keep up and keep getting, you know, new information and things like that. So that's true.
Yeah, they don't operate them for free.
Yeah. Well, thank you all. I hope I think it was a good class today. Thanks for sharing your thoughts, and hopefully some of the questions were good and you learned something, and thanks for your time. Appreciate it.
Thank you, Jeff.
Thank you,
Thank you,
Jeff.
Jeff.
Always good, Jeff. Thank you, sir.